explain
A second, please.
explain what's going and explain to you what's going on for reasons which are quite elusive to me. Our PowerPoints never work on this laptop. So this is a PDF, so I'll just be scrolling along through the PDF. So to Zoom or not to Zoom, why bylaws really truly matter. I want to thank Anders for engaging with me in a fairly interesting and comprehensive, I think, discussion over email about this very issue and a phone call. So I'm going to take you through very quickly the highlights. How did we get here? The two cases, Farish versus Delta Hospice Society and Wheatley versus Victoria Canoe and Kayak Club. What does it all mean? And the question which I'm sure most of you have, which is, can we hold our AGM via Zoom? And then I'll let you know about some of the advocacy that we and Vantage Point and the Vancouver Foundation have been doing. And yes, I am a lawyer, but this is not legal advice. It is legal information. So first question, how did we get here? Well, we all know that prior to 2016, virtual electronic meetings were not specifically permitted, whether in the Societies Act or in common law. The Societies Act was amended in 2016 to allow such meetings unless the bylaws stated otherwise, which is critical language, and we'll come back to it. And there wasn't, as far as I can recall, a lot of activity around this because most organizations were proceeding in person. I did come across an organization that had a specific prohibition against electronic meetings in its bylaws, but that's probably one of thousands I've looked at. And then along came our friend COVID-19 and the ministerial orders that explicitly allowed societies to hold meetings electronically. And then in May of 2021, the Finance Statutes Amendment Act repealed the orders and further amended the Societies Act with regard to processes for virtual and electronic meetings. From April 21st to 2020, I think it's important to remember to May of 2021 and even well into 2021 for most of you, societies were only holding general meetings by electronic means and as a consequence could only vote by such means. So we developed, I think, a certain habit, you might say, and we discovered that it's a lot easier to organize meetings and there's value to continuing to hold electronic meetings. So for many of you, I'm sure it comes as a bit of a surprise to find out that the BC Supreme Court in Farish and Delta Hospice was asked, in effect, to nullify actions taken at an electronic meeting held by the society. The court found that while Section 83 of the Societies Act allowed electronic meetings, they needed to review all the bylaws, particularly as they related to electronic voting. In particular, they considered the use of the terms present, place, and show of hands, and found that while an electronic meeting is permitted, voting electronically at such a meeting is not, because the implication of the words present, place, and show of hands is that the meeting would be in person. So that comes as a bit of a surprise. That has been the case for, that case came down, I think, in November of 2021, late in 2021. It wasn't clear, though, that this, I mean, we certainly, many of us in the field were recommending amending bylaws to those societies we work with to specifically include electronic meetings, also encouraging folks to return to in person if that's what they so desired, if they could. And along then came, needless to say, a conflict which arose in January of 2022 between Mr. Wheatley and the Victoria Canoe and Kayak Club. And this is a decision of the Civil Resolution Tribunal. For those of you who do not know what the Civil Resolution Tribunal does, it resolves disputes under the Societies Act. Pretty much if you have what I like to call a mischievous member or a member with a specific issue that they take issue with, they're the ones that are going to file a claim with the Civil Resolution Tribunal. And indeed, Mr. Wheatley has now filed 3 such claims. The situation arose 3 days before the AGM when he called into question the holding of an electronic meeting. Have to remember, might be interesting to folks to know that the Victoria Canoe and Kayak Club has several hundred members. It's all volunteers. It is a club that exists for the to support canoeing and kayaking in the Victoria area. So the CRT, which issued its decision in June, so some 6 months later, followed the court's decision in Farish very closely, quoting it word for verbatim. And as a consequence, that decision starts to give us some concern because of the number of files that certainly some of us are seeing of individuals taking claims to the CRT. It's much more difficult to go to court than it is to go to the Civil Resolution Tribunal. And there the tribunal found that while they could hold an electronic meeting, they can't vote at these electronic meetings unless their bylaws are amended to allow for that. So what does this all mean? Well, most of you have either the Schedule B model bylaws as attached to the previous Society Act, or the Schedule 1 model bylaws attached to the Societies Act. Neither the former Schedule B nor the pre-July 1, 2022 Schedule 1 model bylaws provide for voting electronically. In fact, most bylaws of most societies that I've seen make no mention of electronic meetings or electronic voting. And those Schedule Bs and Schedule 1s say things like voting must be by show of hands or by ballot, which can be read as implying that voting must be in person and therefore so must meetings. So you can see the problem exists for many of you unless you have an explicit bylaw that allows electronic meetings. The Model 1 bylaws that were attached to the Societies Act have been amended in July, and they use the word attendance instead of present. They also add the words as applicable in the section setting out the place of the meeting. So that in their view, in the ministry's view, this would satisfy the court and by extension the CRT that electronic meetings can be held. I'm not entirely convinced that a court is necessarily going to see the words as applicable, given superseding anything else in the bylaws, because while some of the language has changed, I don't know that it goes far enough, in that even though it's not supposed to be this way, the court pretty much said if your bylaws don't allow it, it's probably not allowed. So I have some concerns about that. And I would argue that you know, the provisions around voting and secret ballots, I think most people, the idea of that conjures up paper ballots like we would use when we vote for mayor in a week or 2 weeks or whenever that is. So in any event, the amendments to the Act do authorize electronic general meetings in most cases. It allows societies to do the business they need to do more efficiently and reduce carbon emissions, no travel to meetings, reach more people. There's lots of advantages to it. But it makes no sense to us that if electronic general meetings were authorized, it seems to us, then ipso facto, so is electronic voting. It's our view that you can't have one without the other. And this is really, in essence, the problem that societies are going to have. The question is not whether or not you can have the meeting electronically. It's what do you vote? How are you going to vote? And is it possible to do it electronically, given these cases? So the question then is it safe to hold an AGM via Zoom? Now, I'm going to give you some ideas. This is not definitive by any means. And like with many things involving your bylaws or involving society disputes, there's always going to be some nuance, and a lot of it's going to depend on the particular circumstances and the particular bylaws. The single most important factor to consider is going to be how many members do you have? If you are the Vancouver International Film Festival, you have 11,000 members, the likelihood that there might be somebody who gets a bee in their bonnet starts to increase the more people that you have attending such meetings and perhaps disagreeing with amended changes in bylaws. These are not the only, there are a number of other issues that have arisen that are causing some concern in this sector, and bylaws are being, in some cases, tightened up. So anytime you have the possibility of a disagreement, you have to consider, you know, the likelihood that there could be a claim made to the CRT. Now, if the only members of the society are the directors, right, then you could make the judgment call that since it's basically a pro forma meeting, you do the same thing every year, and the slate of directors are acclaimed. There's no voting, choosing between directors. It's possible to hold that meeting. Now, it's arguable that that meeting is contrary to the Societies Act if there was voting involved. However, the reality for most of us is that the likelihood of enforcement is virtually nil unless there's a dispute to the Civil Resolution Tribunal. So I'm not recommending that you ignore the Societies Act or the decision in Farish. What I'm suggesting is that if you've already gone the distance and your meeting is in 2 weeks, and you have good reason to hold it electronically, whether it's vulnerable community members or you cover a wide geography. The issue then is really going to be, how are you going to handle voting? And this is the instance where one of the possible workarounds is more procedural, which is, in the case of when you proceed by way of acclamation, there is no vote. So there's no reason to vote in that instance. No amending of bylaws. Again, there doesn't need to be a vote if you're not amending bylaws. Obviously, if you're trying to amend bylaws, there would have to be a vote recorded. And
Martha, if I can just interrupt there, in terms of, I'm just looking at the question. So for example, in the case of needing to then update bylaws to address some of what you've been sharing. I'm sorry, I don't know why it's recording my a thumbs up. 1 second here. I think Zoom got smarter and it's trying to assess that I'm giving a physical thumbs up, and then it gives me one in the virtual. So the question from Christian Wilhelmsen is, does this mean in order to change your bylaws, you have to have an in-person meeting?
Basically, yeah.
Okay.
Yeah.
Thank you, Martha. Just while we're here,
unless the only members of the society are the directors and you have 100% unanimity on the process.
Yeah, gotcha. Any comments in terms of addressing how strata corporations are affected?
No, not a strata lawyer, sorry.
Okay, thank you. There is a general question around what platforms people are using for virtual meetings and how to conduct voting. But what you're describing here is, I mean, from my own experience, a lot of organizations are using Zoom by way of a platform for the electronic meeting. But what you're suggesting is that currently bylaws are likely written in such a way that conducting electronic voting is actually not possible.
Yeah, it's technically offside the Societies Act. The court's very clear. You can hold an electronic meeting, you just can't vote at it, which begs the question, well, what do you do at the electronic meeting? The only option, this is why I say it's procedural. I mean, we have a convention, right, of passing resolutions and getting them seconded, nominated, or whatever the language is, and seconded, and then passing and everybody puts their hand up. Well, theoretically, a board could present the agenda and simply call the meeting to order. The chair can call the meeting to order, and they can proceed procedurally without getting a vote from the members. You present reports, you present the financial statements. There's no reason to vote on any of that. So you could, in theory, have a meeting, unless your bylaws require that you follow Robert's rules, in which case you can't do this, arguably. You can hold a meeting without voting. Assuming that your directors are all acclaimed. So, but this is a risky strategy. If you're presenting anything new to the membership, if you have a restive membership, if anything has happened in the previous year that is potentially an issue that somebody's going to raise, then it's a risky strategy. And, the reality is that given the situation, until you change your bylaws, yes, the recommendation is you do it in person.
Okay, Martha. So some great questions coming in on the chat that I'll summarize for you, Martha, just because they are timely to this. So you're going to get to what then you need to change in your bylaws. So that's still to come. But in terms of the meetings that have happened, the last 2 years of meetings where it turns out that any voting we did is actually would not be upheld. Those votes would be.
Well, no, with respect to the time frame under which we were dealing with the pandemic restrictions, this does not affect those.
Okay, what timing was that exactly, Martha? I think you
Well,
showed it on the.
Yeah, I can go back.
Okay, so there was a kind of a special period when, yes, we were allowed to have electronic meetings, and yes, we were allowed to hold electronic votes. So through May 6, 2021. Thank you, because that seems important to some of the conversation. And then, but Martha, even if a meeting was held since May 6, 2021, in effect, it doesn't nullify the meeting. But if you, let's say you amended your bylaws and had an electronic vote between May 6, 2021 and today, and you amended your bylaws and there was a vote to approve the new bylaws, tell me, what if nobody complains about the vote? Is that okay?
I mean, you know, I'm a lawyer, and you know, you're required to follow the law. This is where I would use language like, there's a risk, you know, that somebody could come back and say that was offside of the Societies Act in light of Farish. And I mean, the downside of telling people about this decision is precisely that now people are aware of it and maybe second guessing what happened late last year and early this year. Now, my view of that would be, A, the ministry didn't communicate at all with the sector on the impact of Farish. It made changes to the Model 1, Model 1 bylaws attached to the Societies Act in July of 2022. So they didn't even turn their minds to this issue until July. I think that it would be, I would argue, and in fact, what I would say is if you got a claim before the Civil Resolution Tribunal, I would argue that you should have an in-person or a by phone hearing. You should be getting legal advice and trying to make some arguments around why Farish shouldn't be followed, because for whatever series of reasons we could come up with. I think there's a lot of problems with the way that the CRT made its decision in the VC Casey case. And indeed, they have another one which came down last week, where Mr. Wheatley asks for the register of members, and he clearly is not going to use it for the purposes under the Act, but somehow that got past the member. So I wouldn't over worry this. I really wouldn't. I'm not suggesting people should panic. I think that you all know who in your membership could be raise the issue. If you are concerned about it because something has happened in the last 6 months, then perhaps what you do at the AGM is you pass a motion, again, codifying, if you will, the decisions made in the meeting that was held electronically in September of 2021. So if you were holding your AGM in October and you've changed your bylaws and you have electronic meetings in there, then I would, or you're in person, then I would have like a retrospective vote that would just solidify, if you will, that these changed bylaws were approved of by the majority of members at that meeting.
I'm trying to clean up the last of things before we move on, just from the chat. So we have an organization, they're a provincial organization, their bylaws allow for electronic voting. And only the board is able to vote at the AGM. They have other types of members that I guess have different member rights. I'm guessing.
Well,
that
they're
don't
going to
even-
need to have different member rights if the board is the only people voting.
And they're provincial, and they've always held virtual meetings. And I guess their bylaws are equipped to do so. But without going into even more detail than that, any other comments there on that particular case?
No,
Okay.
I don't know how you, again, remember, like, this is actually a good segue into the bylaw changes.
Yeah, why don't you do that, Martha?
Right, is first of all, in the definition section in your bylaws, we recommend that you add a definition of what you mean by electronic means. So in this case, it's a pretty broad computer, web-based, electronic, telephonic, mail even, communication facility that, in relation to a meeting, permits all participants to communicate with each other or otherwise participate in the proceeding contemporaneously in a manner comparable but not necessarily identical to a meeting where all were present in the same location, and in relation to a vote permits voters to cast a vote on the matter for determination in a manner that adequately discloses the intentions of the voters. Now, I will say that if you've been holding your meetings by telephone, I don't think that that's adequate for somebody to discern first of all, the identity of the person. Any number of people could be, it's not the same as video technology that allows you to see one another, right? It's a very different way of doing things. So, but if you've always done it that way and nobody's ever raised it, if it ain't broke, don't fix it, I guess. The other change.
Just Martha, if you can just go back to the previous slide. So if this definition is in your bylaws, this would put you in the clear, and that it would permit electronic voting at an electronic meeting.
Well, not quite.
Okay.
It does. This is the definition section. The
Okay.
critical section is this: the time and place of a general meeting. And there's 3 sections to this bylaw. A general meeting must be held at the time and place the board determines. That's the current language. The board may determine in its discretion to hold any general meeting in whole or in part by electronic means, so as to allow some or all members to participate in the meeting remotely. This is where you get the specifics of how it's going to take place. Where it is conducted using electronic means, the board must take reasonable steps to ensure that all participants are able to communicate and participate in the meeting adequately, and in particular that remote participants are able to participate in a manner comparable to participants present in person, if any. Persons participating by permitted electronic means are deemed to be present in person at the general meeting. Now there's variations on this drafting, depends on the lawyer, etc. But this is explicit, right? This is where you make it very clear that this is how these meetings are going to take place. You would have to identify the platform on the notice. You would have to give them, perhaps explain how the voting is going to work. There's lots of additional material that you may be expected to provide your members when you are proceeding electronically, particularly in the case of a vote. And you need to be very careful. Also, if you have language in your bylaws that stipulate that 2 members could call for a secret ballot. So you have to remember that secret ballots have to be secret, which means you need a voting platform that allows for secrecy, which arguably Zoom does not. So, and part of the reason for that is because the people looking at the Zoom screen can see, or the hosts can see the vote. If you were to try to vote privately, for example, it's a question in my mind anyway, whether or not that would be adequate secrecy to meet the standard of a secret ballot. Incidentally, there's no requirement in the Societies Act to hold a secret ballot. So that language in the bylaws, you may need to rethink, or you could rethink it as well.
Yeah. Just some timely comments, questions here, Martha. In terms, let's say a group wants to amend their bylaws, have new bylaws approved that reflect these changes that you're describing. If that meeting were to be held hybrid, would only the in-person votes then count?
Not if your bylaws allow for electronic voting.
Currently, but if they have yet to integrate that change, your recommendation would be just hold your meeting in person.
Yeah, if you haven't made the changes yet, yeah, I'd say hold it in person. I mean, remember, you can always have people attend remotely. It's just a question is whether or not they can vote.
Yeah.
And there's other ways around it too. You can propose a ballot in advance of a meeting, as long as you provide, there would have to be notice and a specific procedure followed. And, it's arguable that it could get tossed, but, the issue really is notifying people and making sure that they can communicate one to another, and that the voting can be done in a manner that is comparable to what would happen in person.
Yeah. If you've got the definition of what electronic means is in the definition section of your bylaws, do you then have to also have it explained again as part of the time and place?
Yes.
Okay.
Yeah, because this is just a definition of what we mean by electronic means. I'm saying that the board should have the discretion on what place, and that place could include a platform. So one option is, some of us have changed the language. A general meeting must be held at the time, place, and by whatever means the board determines, and then explain more fully. These sections also allow for more of a hybrid meeting than strictly one or the other. And then there are other lawyers, or drafting, or bylaw drafters that are going to say you want specific things in your bylaws around voting. That's another place that you would want to put it, but the definition is helpful, but it isn't enough.
Okay.
In my view.
Triple checking, Martha, that none of this applies. This is applying to annual or to general meetings rather than meetings of the directors.
Absolutely. Directors can do whatever they want. They can hold their meetings via WhatsApp if they want.
Okay, that's great. Some suggestion that for the secret ballot solution, that using a Zoom poll is a reasonable way to accomplish that. Again, assuming your bylaws permit electronic voting. Does that sound reasonable to you? Any concerns with Zoom poll, which is sort of effectively a quick form question that people respond to?
Yeah, the issue that is going to arise if I'm going to be really persnickety is going to be How do we know that the person who answered the poll is the person who we saw on the screen?
Right.
Yeah, like it's, see,
And are they a member? So for example, like in Vantage Point's case, we have a lot of people come to our AGM, they're not all voting members.
exactly. So, you know, like you think it might work, you think it's secret, I guess, but remember, you know, and again, I do want to stress this. This is about, are your members, you know, if you have hundreds of members and you don't know who they are, and you know you're dealing with issues in the community where people are going to get their knickers in a knot, then you already know that you're vulnerable. However, if you're a society that's never had an issue, you're a bunch of quilters and you love quilting and it's all groovy, then, you know, if it ain't broke, don't fix it. Don't worry, you know, it's all good. However, you know, all it takes is one person and they go to the CRT and they're going to raise this issue. And all I'm trying to do, and I think most of us want to do, is, sadly, I mean, you know, we've all been through this with the transition. I think we're going to have to look again at these model bylaws and add some things, because, you know, there's issues with access to records that are popping up. There's restrictions that need to be there on your accounting records for sure. And
Okay.
again, this is in my view, you know, so I think that there's a real need for people to look at their bylaws and consider any number of changes.
Sure. Another good question. If your bylaws permit voting in advance, electronically in advance of the AGM for election of directors, especially, is the question. So if director elections are taking place in advance of the AGM by electronic means of some kind, where does that, and then the vote is announced at the AGM, where does that fit in?
Well, that's where that is one. Well, that actually came up in another case at the CRT, where there was a vote held in advance, and there was nothing in the bylaws that specifically enabled that, and the CRT found that that vote was what they had to redo it. It was, I think, voting on a budget or something. I can't remember. It's one of the manufactured homes or resident association cases from 2021.
Okay.
Yeah, I think you have to be really careful about electronic voting, particularly where, if you have, again, a significant membership base. And I do think that, you know, I've raised this in a lot of workshops I did on the transition to the new act in between 2016 and 2018. It's not so new anymore. Is, you know, do you know who your members are? Like, you know, a lot of us have these lists that no one even knows who these people are. And that's really, you know, the issue that, you know, when we did the webinar on membership structures, Mark and I, and, you know, there's a reason for that. And it's because we really need to think about this. We've been allowed to think by fundraisers, for example, that all donors should automatically become members. You know, I disagree with that approach, shall we say.
Yeah, and somebody in the chat just reinforcing the point you've made around, say, the use of Zoom polls, that not only you need to know really who's filling it in, are they a member and a member in good standing, and so on. Just to share the solution that we came up with in case we needed a secret vote or an anonymous by secret ballot vote, was to use a simple form structure. So we set up the form in advance for the votes that we knew of. We ended up not needing it, but that was going to be our solution. I'm not sure exactly the tech, whether it was Microsoft Forms. It was some fairly simple approach where we could at least ask them to identify the name of the member and so on, so that we could check if we needed to, but we ended up not needing it.
Yeah.
But let's let you carry on, Martha, here.
Yeah, I'm just about done. I just wanted to let people know that that we met with the parliamentary secretary, Nikki Sharma, on behalf of the Minister of Finance, the Honorable Selena Robinson, and we've asked them to consider an amendment to the ACTA regs where both procedures and requirements for electronic meetings and voting, at least basic ones, could be added to the Act, taking the burden off of societies, particularly those that are most impacted by CRT disputes, which are the all volunteer or virtually so groups that have significant memberships, often of residents or community members, where there's a prospect of a dispute. These are that's our website for those who don't know it, and that's it. So I'm going to stop sharing so I can see your smiling faces.
I've done my very best. I think I've got most of the questions. There might be something from way back, but I would like to invite maybe some hand raising if for those that had a question and they feel it's not been addressed. Feel free to pop your hand up and I'll take them in order. Yeah, Eastside Art Society.
Esther.
Sure.
Hi.
So, hi, Martha. How's it going? So your last comment, does that then mean that we don't have to all put together special resolutions at our next AGM to
no.
change these various different
You will have
bylaws?
to, if you're going to change your bylaws.
No, okay.
Resolution, unless we could convince the ministers, Selena Robinson and Murray Rankin, respectively, to amend the legislation, or simply do it by regulation, like they've done making the changes to the model bylaws. We've also strenuously asked them to.
Okay, so if they do that, then we don't have to change our.
Then you wouldn't have to do anything. But there's been no amendment proposed. Remember, we're talking about legislative change, which moves very slowly at best of times, and this isn't the best of times. That being said, any of you who have who are concerned about this issue, raise it with your MLA. I'm, like, the sector gets very little attention, and Victoria Canoe and Kayak Club are in the process of requesting a meeting with Murray Rankin, and the reason is because he's their MLA, and they can make the case very strongly. I mean, they've had 3 different decisions from the CRT. They've had to redo their meetings twice because of one person. And it's an onerous burden on an all volunteer group. It's ridiculous. Like, this is a waste of, and not to mention, frankly, a waste of our money having these disputes go to the CRT. Like, and their backlog is like 6 months. So you find they did their AGM in January, they had to redo it in July. Like, it's nuts. The whole thing, I mean, I find it very unacceptable, but then I find a lot of things unacceptable that happen to this in this space, as some of you probably know.
Folks are hoping to access not just the recording, but the slides to have those notes, and those will go on to the PLEO resource library or Law for, I just want to make sure.
It'll be on PLEO, and we're going to hopefully get it up on Vantage Point as well. I'm going to finagle the slides a bit because there's a couple of things I think I'd like to make a little clearer. I'm a lawyer. Every word is a worry. So I apologize for not having it right now able to send out, but before next week, before I atone for all my sins, I promise I will have it to Maria to send out, and we have created a pick list which identifies bylaws on one side from Schedule B and Model 1s and some suggested changes so that you know what language to use.
Any other questions? I did have a quick scan again. I think I picked up most of them. BC Search and Rescue, did I cover your questions fully? Is there anything dangling from your perspective?
Well, I think so. It's a challenging position. We're a provincial organization, so face-to-face meetings cost us $20,000, and we don't have it in budget. So we do virtual meetings, have done forever before the pandemic. The nice thing is our bylaws allow for it, and the only voting members, even at our AGM, is our board.
Yeah.
We've got 3,000 members, but the bylaws are very clear that our board are voting members. In fact, we held our first virtual AGM with our membership so they could watch, and we had to use the Zoom platform for voting, and then another platform for allowing the members to watch, so we didn't get someone voting who couldn't vote, and that's how we.
Yeah, and you know, and that's the way. See, this is why I come back to the question about who are your voting members and why. Why do we have all these people voting? It's, you know, you can call me anti-democratic. I'm happy for you to call me whatever you want. The reality is that some of you have either done it because you think gaming requires it, or second most common reason is fundraisers have told you it's a way to engage with your donors. Well, most donors don't show up anyway. So what does that mean? Like, this is about the governance of the society, who matters. And, you know, you either have a board that's responsive to its membership, and I would suggest that BC Search and Rescue has demonstrated that it is engaging with its membership because they haven't challenged the decisions of the board at the CRT level, right? Like, this is, you know, this is the problem with the Schedule B and the Schedule 1 model bylaws, is that they are basically inadequate. And you do need to know a few things about governance. And this is where I come back to, and why I think it's really important for us to reach out to the resources like Vantage Point, like our volunteer centers, like Volunteer BC, where there are people who will help board members understand their role, understand these things, and get a handle on governance. You don't need lengthy bylaws. You just need to understand what you're doing and why. And a lot of us, because of the way, you know, there's 29,000 societies. The vast majority of societies never interact with any and have no needs. It's a really small number in actual fact. And but the result of that is that it can be lots of fighting. Infighting does not usually end well. You know, splits in groups, boards arguing. I mean, you know, Delta Hospice lost its funding, but that was, you know, not a problem for the Catholic priest who took it over, because that was their deal. But anyhow, that's another story. Sorry. I'll try to avoid another tangent.
Thanks, Martha. You've done well. We have 6 minutes left, and nobody's sort of got a hand up. So, but we'll take those 6 minutes. We'll use it. Don't worry. Are there, you know, encouraging, if there is a question that still feels like it's dangling? There's lots of thank yous on the chat, Martha, for, as always, your passion and so on. And your partnership in getting this out in an accessible way. I definitely appreciate it, and I would just reinforce this point that regards to the secret ballot, what you said being that the Act doesn't require you to make that possible. I'm not saying it, that's, you know, but what are those moments when we may be complicating governance in such a way that it actually doesn't achieve a great advantage or benefit in terms of our mission or our member engagement?
Yeah.
And we grappled with that around proxy voting when I worked with Martha on Vantage Point's revised bylaws, and our initial instinct was that maybe proxy voting was a good idea, but when we thought through the implications and how much resource it would take to manage proxy voting for a large membership, we realized that actually we would be doing our members a disservice because we would then be directing resources away from running workshops, doing PLEO lunch and learns, all those things just to administer something that wasn't going to offer a whole ton of added value.
And it is can be administratively complex. The other thing, I want to go back to something that our friends at Search and Rescue said, which is, there are groups that have general meetings on a regular basis because they want to engage with their members. And that way, everybody knows what's happening. So the general meeting, the annual general meeting, doesn't become the focus of everybody's attention. And, whenever you're dealing with a contentious issue, my advice always is get out in front of it by convening a community meeting. Don't call it a general meeting, call it a community meeting. Meet with your members, find out what their issues are so that you can get ahead of it. And, particularly when you're dealing with change and transition, which many of us are. The post-pandemic, the impact of the last 2 years is profound. Most of us are dealing with whatever labor shortages, whatever anxiety around coming to work, a lot of things have changed for a lot of us. And, I think this is not the best time for us to be changing everything again. And I think the way to do it is to communicate. And, and understand that there's a difference between having a group of advisors like parent advisors or an advisory council and having a board. The board are the people who are going to decide various key things. Your advisors are there to get into some of the other issues. And they're the ones that should be impacting the daycare, not the advisors who have good ideas, but you can't, if Bobby needs extra help, that is not an issue that should involve the board. And too often it does, because, the parents of a daycare are often the members of the daycare. And having been on a daycare board back in the olden days, you end up spending a lot of time dealing with people who are mad at you for no reason that you can address. I can't address the issues between Bobby and Susie, anyway.
Martha, one last question, and before we say goodbye to everybody, just somebody confirming that we can have both voting and non-voting members if provided for in the bylaws.
Yes. If you have non-voting members, you need to be clear that you have 2 classes of members. And I'll say the one thing I've said before, which is there's a difference between a class of member and a category of member. Categories, your silver, gold, and platinum, that has nothing to do with membership or governance. It's class. Do they vote? Don't vote. What role do they have in, this way or that way? People who live here, they're on title, they vote. Their family members are welcome to attend meetings. They don't vote. Simple.
Thanks,
well,
Martha.
not simple. It's never simple.
Martha, always a pleasure, honestly. Thank you so much on behalf of all our participants today, and also those who will be watching this recording after the fact who couldn't be here for the live session, but really appreciate your time, Martha, and your ongoing energy and leadership in this work on behalf of the sector.
Happy to be here. Hi, Lee. Long time no see.
All right, goodbye, everybody. Take care.
Bye.